A federal judge signaled on Wednesday that he had doubts about an extraordinary lawsuit the Trump administration filed against the entire federal bench in Maryland, challenging a standing order intended to briefly slow down the government's ability to deport undocumented immigrants. During a hearing in federal district court in Baltimore, the judge, Thomas T. Cullen, said he had some reservations about the suit, making his remarks even before a lawyer for the Justice Department had the chance to offer any arguments on behalf of the administration. "I don't have a very good poker face," Judge Cullen told the department lawyer Elizabeth Hedges as she stepped up to the lectern to address him. "And you probably picked up on the fact that I have some skepticism." It was clear from the outset of the hearing just how unusual the case was, which amounted to the administration's latest attack on the judiciary. Because all 15 federal judges in Maryland were named as defendants, Judge Cullen, who normally sits in Roanoke, Virginia, was asked to cross state lines to preside over the matter. The judges themselves were excused from being in the courtroom, and some, in fact, were on the bench in other proceedings as the hearing unfolded. Moreover, the judges managed to get Paul Clement, a former Solicitor General, who has argued more than 100 cases in front of the Supreme Court, to represent them. Out of the gate, Mr. Clement emphasized the bizarre nature of the government's efforts. "This is, to state the obvious," he told Judge Cullen, "not an ordinary lawsuit." The administration filed the suit in June, about a month after the chief federal judge in Maryland, George L. Russell III, issued the standing order saying that immigrants who sought to contest their removal from the country by filing what is known as a habeas petition would automatically be granted a 2-day reprieve from being expelled by the government. The order was put in place as a way to give judges time to figure out the complicated legal issues in a flurry of fast-paced cases being filed in Maryland, contesting the White House's aggressive deportation policies. The most prominent was a lawsuit challenging the removal of Kilmar Armando Abrego Garcia, a Salvadoran immigrant who was wrongfully returned to his homeland in March. The suit came during a moment of excruciating tension between the administration and federal judges across the country, who in recent months have issued an avalanche of injunctions against several different parts of President Trump's policy agenda. But the spectacle of the White House suing an entire district court in the name of the United States of America underscored just how rancorous relations between the two branches had become. In his arguments to Judge Cullen, Mr. Clement said the suit was a fundamental violation of the separation of powers laid out in the U.S. Constitution. While federal agencies or specific government officials might be able to bring legal claims against the courts, he said, the executive branch as a whole could not do so. After all, he reasoned, if the government could sue an entire district court, where would it end? Could the White House sue a federal appeals court that issued an order it did not like? Or could it sue the Supreme Court? What the government should have done, Mr. Clement told Judge Cullen, was either to have challenged the district's standing order in front of the State Judicial Council, which acts as an administrative body for the court, or to have appealed it in one of the individual cases in which it was actually imposed. Mr. Clement also warned of the nightmare scenarios that could emerge if the lawsuit was allowed to move forward. He said there would be all kinds of thorny legal problems if, say, White House officials had to be deposed about why they had brought the lawsuit, or the judges themselves were made to testify under oath about why they had issued the standing order. Speaking for the Justice Department, Ms. Hedges sought to play down such concerns. As a preliminary matter, she said that the Trump administration had no plans to sue any other courts, acknowledging that the Maryland suit was something that was not likely to, quote, occur more than once in a generation. Still, Ms. Hedges stood behind the administration's claims that the 2-day pause in deportation cases inhibited the White House's ability to enforce federal immigration law. She also argued that because the order was imposed automatically, it failed to meet the normal legal thresholds needed to impose injunctions on the government. "This is an extraordinary standing order, and so we find ourselves in this position," she said. Judge Cullen told both sides that he intended to hand down a decision in the case by Labor Day, acknowledging that it would most likely be appealed and make its way to higher courts.